All right. Well, why don't we go ahead and get things started? Welcome, everybody, to our monthly Legal Lowdown series for small business owners, where we tackle a different topic each month that is, I think, very relatable to most small business owners. And this month, we're going to be talking about myths relating to the differences between employees and independent contractors. So my name is Mike Fiffik. I'm the managing member here at Fiffik Law Group, and we provide a variety of services in Pennsylvania, but we do a lot of work for small business owners, from formation to growing their businesses, mature stage businesses, and then even those that are in the succession planning and exit phase. And I've represented all different types of businesses over the 32 years that I've been practicing law. As you might imagine, we dealt with a lot of them, including real estate developers and restaurants, entertainment venues, medical practices, professional practices of one kind or another, retail stores, construction and contractors, trucking companies, childcare providers, lots of different franchise owners. So we really have a lot of experience when it comes to the small business community and can provide a lot of advice and counsel for small businesses. And we represent small businesses all over the state. Our offices are in Pittsburgh and Radnor, and I also have an evening office in a community just north of Pittsburgh called Allison Park. And we represent a lot of small businesses and meet them in those areas. Although a lot of small business owners do a lot of work online. So let's talk a little bit today about what our agenda is. We're going to talk a little bit about independent contracting and the fact that it's on the rise in the United States. And we'll talk about worker misclassification, what that is and why it's a big deal for small businesses. We're going to talk about 5 myths about independent contractors and why these can hurt your business. And we're going to talk a little bit also about factors for proper worker classification so that you don't end up in a pickle because you have misclassified your workers and you're paying them or treating them incorrectly. So why don't we just jump right on in? So independent contracting is on the rise. There are two types of workers. They fall into basically two different buckets for small businesses, right? You've got employees in the traditional sense of the word, somebody that works for you. But then there are also a category of workers that we call independent contractors that also can provide services to your business. Those are the two buckets that most workers are going to fall into for small businesses. And the bucket of independent contractors is growing, right? So according to this 2023 study by the Upjohn Institute, independent contractors make up about 15% of the workforce. And that might seem relatively small. And quite frankly, I think it's probably a little bit underreported. But that's an increase from about 8% just about 5 years ago. So it's doubled over the last 5 years. And I think that's a pretty significant increase. The US Government Accountability Office reports that about a third of businesses use independent contractors or classify some of their workers as independent contractors. And I think that's probably about right. So there are a lot of businesses that do that. And I would say that if you look at the whole spectrum of businesses, right? Probably there are more independent contractors with small businesses rather than larger businesses. I think so. This is really a great topic for small business owners to pay attention to. The Pennsylvania Attorney General reports 10 to 20% of businesses misclassify at least one worker as an independent contractor. And I also think that that's probably um, too low of a number. I bet you that the number is probably closer to about a third because it's very common for small businesses to have independent contractors, at least from my point of view, whenever they do have workers of one kind or another. So, there's a significant segment of the small business community that independent contracting applies to, that this topic of classification of workers and the problems that arise out of misclassification arise. So we really need to be paying attention to this. So what is misclassification exactly? What is that? And again, it's really just deciding which bucket your workers fall into, whether they should be an employee or an independent contractor. But it goes beyond that. So let's say that you have characterized or classified a worker as an employee, then they get further classified as exempt versus non-exempt for purposes of the Fair Labor Standards Act in the IRS. And that's important for decisions relating to whether they are to be paid minimum wage or whether they are to be paid overtime for work over and above 40 hours in a week. And the rules or the laws that are applicable to this are the Fair Labor Standards Act. That's a federal statute that applies pretty much to all workers in the United States, and the Pennsylvania wage and hour laws if your business is located in Pennsylvania. But I will say that every state, no matter where the small business is located, likely has some type of wage and hour law that applies to those small businesses. And then finally, the Internal Revenue Code has a lot to say about this classification topic. And in fact, that's where a lot of the statutes and the regulations originate that relate to this. So let me give you, here's a little bit of a chart that helps us understand a little bit more about why this question is important. It's really because the labor rights and protections that apply to employees versus independent contractors are significantly different. So here you can see employees have a right to organize and bargain collectively, to basically to unionize. Independent contractors don't have that. And you may have seen somewhere in the news various efforts by Uber drivers, right? Or, other folks like that who are independent contractors looking to try to get certified as employees so that they can collectively bargain and unionize. So that's why that characterization is important. Minimum wage and overtime protections apply to workers that are classified as employees, but they don't apply to independent contractors. Employees, if they lose their job, have access to unemployment comp benefits, but independent contractors do not. If an employee is injured on the job, they can claim workers' compensation and try to get benefits to pay for their medical expenses or their lost wages. Independent contractors don't have those rights. For employees, they are entitled to have contributions by the employer to their Social Security and maybe retirement benefits, but independent contractors are going to have to pay all of that out of their own compensation. So they don't share that expense burden with their employer. And various laws like the laws relating to discrimination or sexual harassment, age discrimination, gender discrimination, those types of protections under the federal and state laws apply to employees, but they really don't apply to independent contractors. So from the worker's perspective, right, how you are classified is a big deal because you can see that you get a whole host of protections under the law whenever you're characterized as an employee, but you don't get any of them when you are characterized as an independent contractor. So let's take another look at this, and we'll look at it from the standpoint of dollars and cents. And I think that this will also help you understand why small business owners might characterize workers as independent contractors versus employees. So here we have two workers that make the same amount of money, right? And you'll see that for the employee, right, they might get some supplemental pay of a couple $1,000s, but the independent contractor may not get that. Some employees have paid leave, like paid time off. That's not something that an independent contractor can get. The employee may get insurance, like health insurance, a contribution to health insurance, or maybe their health insurance is paid. They may get some type of contribution towards retirement benefits, right? This example assumes that there is some type of employer contribution to those types of benefits. That has real value to the employee, but the independent contractor gets nothing, right? Let's jump down here to contributions to Social Security and Medicare. If you are an employee, a W-2 employee, and you get a paycheck and there are deductions from your paycheck, you'll see that you, you are contributing to Social Security and Medicare, right? And you're only paying half of the amount that needs to be paid in on a monthly basis for those benefits. Your employer is paying the other half, basically, right? So they're picking up half of the tab for the employee. Well, for the independent contractor, the employer doesn't pay any of that, and the independent contractor has to pay both sides of that out of their money that they're being paid for the work that they're doing. And so at the bottom line here is that the net value of being characterized as an employee for a worker in our example is over $52,000. But the value to the independent contractor is a little over $35,000. That's a pretty big difference dollars and cents wise on regular pay of $43,000. So you can understand why this is a big issue for employees because it they just end up with less money in their pocket if they're characterized as an independent contractor. And also for small businesses, this is why they want to characterize people as independent contractors because it frankly costs them less. They reduce the cost of labor to their business. That's what a lot of small business owners are thinking about whenever they decide to pay somebody as an independent contractor. Well, this is a big deal beyond just the money, right? From a business owner's perspective, if you engage in misclassification and you get caught, right? And you get caught, here are the risks that you have. There might be a regulatory investigation, or maybe you just get sued by your workers for the misclassification. And neither of those are very good because they're going to be disruptive to you operating your business. You're going to have an expense to deal with these types of things. You don't want to have your state or the federal regulator send you a nasty gram that says, we're going to show up at your business probably tomorrow because they always come with very short notice. And we want to audit all of the personnel files for your workers because they're going to determine whether you're classifying your folks correctly, right? Well, we'll talk a little bit more about that later. If you do get caught, you could be liable to pay for back pay, for straight time or overtime. If that person that you've classified as an independent contractor was entitled to overtime and you didn't pay that, then you may end up getting stuck paying that money. So even more expense. You may also get stuck paying back payroll taxes that you failed to remit to the government. Most wage laws also require employers to pay a penalty and maybe interest on the money that they should have paid. In Pennsylvania, there's a 25% penalty under the wage payment and collection law whenever you have failed to pay wages that your workers are due. So that's a pretty big penalty, 25%. And then also, these workers may be retroactively entitled to benefits, retirement contributions, these types of things. Not only is that an expense to catch them up to what you should have been paying, but it's now an ongoing increased expense to your business to add that person to your overall expense load for your business. So there are a lot of downsides for you. This last bullet point is really important for small business owners to understand, and that's that you could be personally liable for all of these expenses, right? Most wage laws are going to hold the the decision maker, the business owner, right, and perhaps other decision makers in your business, even if they aren't owners, personally liable for these unpaid wage claims. at the end of the day. So this is an exception. Even if you have a limited liability company or a corporation or some other business entity that has a limited liability component to it, that liability protection, that liability protection that applies to most things is not going to protect you when it comes to unpaid wage claims that arise out of misclassification of your workers. So that's a big deal. Most small business owners don't want to be personally liable for the expenses of operating their business. So this is a really good reason to pay close attention to this as a small business owner. So here's a couple of case studies that are local here to Pittsburgh. The first case study, the federal court required a staffing agency and its owner to pay over $200,000 in back wages and liquidated damages to home healthcare workers who were misclassified as independent contractors. The employer failed to pay them their full wages, probably failed to pay them some overtime benefits as well. And so that was a pretty big bite. I am sure that that home care agency was very unhappy that they ended up with that bill. And that $200,000, I mean, if this was in federal court, they incurred an enormous amount of expenses in legal fees and costs and disruption in fighting this thing, right? So the true expense to that business was well beyond the $208,000 penalty for back wages and liquidated damages that this company ended up having to pay. So I bet that it was at least double that. Case study number two, right? Investigators from the U.S. Department of Labor's Wage and Hour Division dug into a cleaning services business, and they found that they misclassified 59 workers as independent contractors. They were paying them straight time for all hours worked, over 40 rather than time and a half for overtime. And so they were required to pay $53,000 in back wages and liquidated damages as well. So that's another big bite, along the way, not only to cover them for the money that they owed them in the past, but now their expense of using all of these folks in the future could possibly be much, much higher, right? Because they're going to have to pay them overtime. Or if they want to avoid overtime, they might have to hire more workers so that they're not paying overtime wages to everybody. That business is really going to have to adjust exactly how it is that they're doing business along the way. And so as I continue on, I was remiss. I should have offered or suggested to you that you can plug questions into the chat. I'll certainly be looking at those along the way here and be happy to answer any questions that you have about any of these things that we're talking about here. So let's dig into some independent contractor myths. These are things that I hear all the time from small business owners who are using folks or classifying workers as independent contractors. And this is sort of the rationales. This is some of the rationales that they use to characterize them as independent contractors. So the first one is they wanted to be classified that way, right? Well, classification is not a choice. Workers cannot opt out of being classified as an employee, right? The law dictates the law and the facts of that the worker's relationship with your business dictates whether they are classified as an employee or an independent contractor. So there's not some kind of box that they can check to say, I want to be treated as an independent contractor, right? Here's the definition of employee or employee under the Fair Labor Standards Act, the federal law that applies to the vast majority of workers. It says to suffer or permit to work. And that was specifically designed to broadly cover as many workers as possible. So the law, as it's written, right, is tilted in favor of classifying workers as employees. That's just the way the system is designed. You have to understand that. So if you want to classify your workers as independent contractors, you're kind of swimming upstream, right? Because that's not really the way the system wants those folks to be characterized. That's not really the way the law is written. And again, I had touched on the economic reality. That's a phrase that is commonly used in this classification area of law. The economic reality of the worker's relationship with the employer and the employment, right, the work that they're doing, determines whether they are economically dependent on the employer and therefore an employee, or if they're a business for themselves and therefore an independent contractor. So you just the takeaway here is it's not a choice, right? An employee cannot agree to be classified one way or the other. They can't choose to be classified one way or the other. You could have an agreement that says they've chosen to be classified as independent contractors. Doesn't matter. That's not enforceable. So that kind of leads us into myth number two. We have an written agreement with this worker that says that they are an independent contractor. So therefore, that's what they are. You know, having an agreement with somebody that you've classified as an independent contractor is helpful for lots of reasons, right? There are lots of reasons why you want to put on paper what the relationship is between you and that worker. You know, what they're going to do, what they're not going to do, how much you're going to pay them, when you're going to pay them, under what circumstances you don't have to pay them, what they have to do in order to be entitled to get paid, what happens if they don't do the work that you've assigned to them, and so on and so forth. There are a lot of reasons why you might want to have something in writing with a worker that is an independent contractor. But a provision in that agreement that says we've agreed that this person is an independent contractor doesn't mean that they're an independent contractor. That doesn't matter at all. Okay. Now, in some instances, if you have somebody that is classified as an independent contractor, the law mandates that you have that in writing. And so the construction industry, at least in Pennsylvania, is one of those where it is mandatory. If you're going to pay a worker as an independent contractor, you have to have a written agreement with them. If you don't, then they're going to be treated as employees under the law. So number three, independent contractor myth. Small businesses are exempt from the rules relating to worker classification. That is totally a myth. Worker classification applies to all employers. It doesn't really matter where you are, what size you are, what you do. Okay, doesn't matter. It applies to everybody. There is no exception for a small number of workers, like there are other laws that relate to workers, like the Family and Medical Leave Act, or the COBRA for the portability of health insurance. There are some employment related laws that apply to workers that don't apply for businesses that have below a certain number of employees. So for FMLA, it's 50. Below 50, it doesn't apply to you. But classification applies to every business, even if you only have one worker, it is something that still applies to you. And it also applies no matter what kind of a business entity you use, whether it's an LLC, corporation, even if you're a sole proprietor doing business as, right? If you've got a worker that is working for you, the classification rules still apply to you. You have to pay attention to them. Next myth. It's okay to have my independent contractor use a timesheet. Probably that's not a good idea, especially if you have your employees use a timesheet as well. So if you're paying independent contractors in the same manner as the employees, right? They're probably going to be treated as employees. So if you have both of them filling out timesheets, if you pay them both on the same payment cycle, right? If you have them do the same things, you're really doing the same things for both of them. It is pretty difficult to distinguish an employee versus an independent contractor. And this is going to be one of those things that would be looked at by a regulator in determining whether that worker is properly classified. Ideally, if you have somebody that's an independent contractor, you would receive invoices for services rendered by them. And you would pay those invoices in the same manner that you would pay other vendor invoices. So if you pay all of your vendor invoices once a month or bi-monthly or bi-weekly or whatever it is, then that's really what you should do. They really shouldn't be paid on the same payment cycle as your employees. So let's move on to number 5. I'm a small business and I'm unlikely to be audited, right? So you might think, yeah, I've only got 1 or 2 workers. Who's going to pay attention to me? The government's got bigger fish to fry out there. So I'm just going to keep doing what I'm doing. Well, you know, all things being equal, that might be true in many instances, that you can just sort of slide below the radar kind of a thing. But there are so many ways that attention can be brought to the classification of your workers. It's very easy to get caught up in that. Here are some triggers for audits by the regulators, either the federal or the state regulators. This is oftentimes what will trigger one of these and bring the government's scrutiny onto you. Your worker files for unemployment comp and lists you as a former employer, right? That worker doesn't know whether they're entitled to benefits or not. They're just going to apply, right? They're not trying to hurt you necessarily, but they apply to see if they're entitled to benefits. Maybe they're entitled to benefits because of a prior employer and they might still be entitled. But anyway, you could get in the government scrutiny because they've listed you as an actual employer and the government's going to see you haven't paid anything in for this person. Maybe your independent contractor suffers an on-the-job injury. They don't have health insurance and they've got medical bills and they're looking to get those covered. They might just file for workers' comp against you. And now you've got some scrutiny against you, either from your workers' comp carrier, right? Maybe you have workers' comp insurance because you have some employees and some as independent contractors. Now your unemployment or workers' comp carrier is going to wonder whether you have properly classified your workers as employees and you've underpaid for your insurance and they're going to back charge you for premiums to cover these folks that you have misclassified, right? Or maybe you don't have any workers' comp insurance at all, which is a big problem because if that worker is truly an employee, they're going to be entitled to workers' comp benefits, and the state uninsured employer guarantee fund is probably going to step in to pay workers' comp benefits to that worker, and then they're going to come after you for the money. And if you don't have workers' comp insurance, in most states, it's a crime. So you could really be in trouble. And so easy. It's so easy to happen. For example, I've got businesses that run like delivery businesses, right? Maybe it's a local delivery business and they pay these drivers as independent contractors and somebody gets in an accident. I mean, it's really easy how this stuff can come to light. Maybe you have a dispute with one of your workers that you have treated as an independent contractor and they file a complaint with the Department of Labor, the federal or the state Department of Labor. And now the regulator is going to come down on you. Again, very easy to happen. Or maybe the worker files their taxes and you're the only employer listed on Form 1099. If that's the only source of income that they have, just from you, and you're giving them a 1099 for $30,000-$40,000 a year, then the IRS might be wanting to look at this situation to say, you know, this person isn't really a business on their own because they're entirely reliant upon the income that one business pays them. That's going to say to the IRS, this is an employer-employee relationship. It's not an independent contractor relationship. So the IRS could wanting to take a look at that. So if I've scared you enough, you might be wondering, all right, what are the things that I need to do to figure out whether my folks are characterized as employees or independent contractors? So let's look at some of the factors. There are a number of factors that the IRS has set forth, right? There are a gazillion of them. I can't remember how many there are, but there's at least 20. I'm going to talk to you about the ones that I think are the most prevalent, the most applicable for businesses, by and large. The law technically says that none of these factors weighs more than another or is more important than another, right? But these are the ones that I typically see applying in most businesses. 20 factors, there it is. These factors really focus on the economic reality of the relationship between the business and the worker. It's the economic reality. So the worker is going to be deemed an employee if they are economically dependent on the employer, whereas a worker is an independent contractor if they are in business for themselves, right? That they've got a number of customers out there, and if their relationship with you doesn't continue, that really doesn't make or break them. So first factor, is the work that that person is doing integral to your business, right? So if it is, then it's more likely that the worker is economically dependent on your business. So here's an example, right, about what work is integral to your business. So for a construction company that frames residential homes, carpenters are integral to that employer's business because uh, their business is framing homes, and carpentry is an integral part of that. So if you've got workers who are doing carpentry work for your framing business, right, then they're really doing work that is integral to your business. Now, an example of something that's not integral would be somebody that is providing bookkeeping services to your business. That's not integral to your business per se. And somebody that you're paying as an independent contractor to do some bookkeeping for you, they're going to pass this test, right? They're not really going to be considered integral to the work that you do. Um, or here's another one. Same construction company, they may contract with a software developer to create software that assists the company in tracking its bids, right? Or scheduling projects and crews or tracking material orders. That software developer is performing work that's not really integral to that construction company's business, right? And that's more indicative of an independent contractor relationship. Next factor, permanency of the relationship between the business and the worker. A permanent or long-term indefinite relationship with the employer suggests that the worker is an employee. So people in business for themselves are less likely to have these long-term relationships. So, here's an example. An editor has worked for an established publisher for several years. The edits are completed in accordance with the publishing house's specifications using its software, and this person only edits books that are published by the publishing house. That really says that it's kind of a permanent or an indefinite relationship between that editor and that publishing house, and that they're likely to be an employee. In contrast, here's an editor that works intermittently with a bunch of different publishing houses over the last several years. That is not a permanent one-on-one relationship. That is definitely somebody that would be more likely to be an independent contractor. Number three, the degree of control that the business has over what the worker does, right? So independent contractors are typically relatively free of control by an employer. The worker's control over meaningful aspects of the work must be more than theoretical. The worker must actually exercise control over the work that they do. So here's some examples. Here's a registered nurse who provides skilled nursing care in nursing homes as listed by the Beta Nursing Registry in order to be matched with clients, right? The registry interviews the nurse prior to her joining the registry and requires her to undergo training that they provide. The Beta Nursing Registry sends the nurse a listing each week of potential clients and requires the nurse to fill a form out prior to contacting the clients. Beta also requires that the nurse adhere um, to a certain wage rate that they're going to pay them, and can't provide care during any weekend hours. The nurse must inform Beta that she is hired by the client and must contact Beta if they miss work or an appointment with any client. So there's a lot of control here, right? Beta is putting a lot of requirements on that nurse in order to get referrals of customers or clients from beta nurse. Beta wants a lot back from the nurse in the way of data and information, and has a bunch of standards that the nurse has to comply with in order to continue doing business with beta. That's an employee, right? That's an employee. Here's another registered nurse who does the same thing with the Jones Nurse Registry, right? The registry sends the nurse a list each week of potential clients, and that nurse is free to call as many or as few clients as they wish and work for as many or as few of them. The nurse also negotiates their own rates with the client. And in this scenario, there's really not very much control. This is just a referral relationship between Jones Nurse Registry and this nurse. That is more akin to an independent contractor relationship. So relative investment is another factor that is used. So the worker, if they're going to be an independent contractor, should make some type of investment in order uh, to engage in whatever the work is. They should have some type of an investment, right? So an independent contractor typically makes investments that support a business, right? As a business beyond just their particular job. So if you're an actual business and you're in business for yourself, a true independent contractor, you're going to have other expenses related to your business. Maybe you've got some marketing expenses, or you've got bookkeeping or accounting services that you pay somebody to do for your business. Maybe somebody is doing business development for you, or you have some type of a contract for IT services. These are all the types of expenses that regular businesses have. Now, if that worker doesn't have those types of expenses that are, you know, similar to what an independent business would have, then they're going to be more likely to be characterized as a worker, right? Purchasing tools for the job has been deemed to be insufficient investment to make the worker an independent contractor. So, if you're a construction company and you require your workers to bring their own hand tools, that doesn't mean that they're independent contractors, right? That's not going to be sufficient enough to characterize them. So, um, most workers at the end of the day are going to be deemed to be employees rather than independent contractors. That's just the way the system is designed. There are 20 factors that are used. I gave you the four most common that I think apply in most instances that are going to dictate the decision one way or the other. But technically, no single factor is more important than any of the others. And the myths that we talked about, which I hear all the time, you just can't believe the myths, right? They're just not, they're not true. So let me see if we have any questions here.